Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. With me today, I'm Justice Meade. With me is Justice Sullivan and Justice Sachs will be the panel for the cases today. We're going to do our best to see that this runs easily. If for some reason you lose your feed or you're breaking up, we'll pause, and no need to be concerned. We'll get back to you and we'll be able to present your full argument. Each side gets 15 minutes. You needn't take all of your time. We've read your briefs. And with that, our first case is 2019 P 1180, Commonwealth versus ISMAIL. Mr. Sparvento.
Good morning, Your Honor. Attorney Robert Sparvento for the defendant's house appellant, Ali Ismail. May it please the court. As you might have seen from my brief, there are a few different issues, but due to time constraints, I would like to start, if okay with the court, with the fourth issue, I'm going to say the third issue, whether or not the wall could be a dangerous weapon. Now, in this case, what happened was Mr. Ismail and the victim, Touche Ismail, got into a fight, and he pushed her and she hit her head against a wall. I'm saying that this is not a dangerous weapon, and it is different from probably the leading case, Commonwealth versus Sexton, which does say that an inanimate object can be a dangerous weapon, which I'm not saying that it's not. I'm saying our case is different because in the Sexton case, the defendant used the concrete as the actual weapon. He took that person's head and forced that head into the concrete. This case is different, excuse me, because in the Ismail case, he pushed her, she fell and hit her head into the wall. So in essence, all we have here is a simple, quote unquote, a simple assault and battery. We don't have the dangerous weapon because the wall wasn't used as instrumentality. It is rather an unfortunate incident where she hit her head while falling down.
Well, that doesn't view the evidence. Excuse me. That doesn't view the evidence in the light most favorable to the Commonwealth that it was an accident, right?
Oh no, I'm not saying it's an accident. I didn't mean to say accident. That was poor word choice on my behalf, Your Honor.
So he intended to push her, and that push was eventuated in her striking the wall.
Correct. Correct. I didn't mean to say accident. That's just the trial attorney and myself.
So that you argue in your brief
sorry,
that the defendant did not intend to use the wall.
Correct.
But assault and battery dangerous weapon. I'm sorry, assault and battery dangerous weapon is not a specific intent crime.
Correct. Correct. But I'm arguing that the weapon has to be used in some way or form. That the dangerous weapon here was just there. I'd like to equate it, if I may, like almost a hypothetical. If someone is getting into a fight, say in a bathroom, and they're arguing, it escalates, and an individual hits somebody, that person falls and hits her head, say, on a bathtub. I would argue there that would not be a dangerous weapon. That would just be an incident where a person just falls and she hits her head. Where I don't see it to be a dangerous weapon. In that case, I would argue to the jury or to the judge that that's nothing more than an assault and battery. And a required finding of not guilty should have been entered as far as a dangerous weapon. And if the jury believed an assault and battery happened, then a guilty verdict should have been entered just for assault and battery. Do you have any further questions, Your Honor?
Do you agree that the dangerousness of the wall is judged by an objective test?
Yes. I'm not arguing that a dangerous weapon, the wall can never be a dangerous weapon, but it's something that has to be used in that manner, whether it's a concrete. Seems like a lot of the case law deals with, for whatever reason, like a concrete floor. When somebody takes somebody's head and hits them into the concrete floor. This is just a little bit different because it's the wall. And a wall can be a dangerous weapon if it's used in that manner. Or, for example, in this case, if he hit her, took her head, and hit her head against the wall, then yes, I would agree that's assault and battery with a dangerous weapon. But in this case, merely because she fell into the wall, I'm arguing, Your Honors, that it's not a dangerous weapon. It should be nothing more than assault and battery. Okay, thank you. Are there any more questions from the panel for that issue? I'll move on to my next issue. If it pleases the court, the next issue I would like to discuss, where I spent a lot of my time in my brief, is the ineffective argument. The first thing I would like to discuss is one of the things that my brother discusses in his brief, is because I did not move a motion for a new trial at the district court stage. I did not do that based review of the evidence. I believe it is very apparent on the record at the trial stage. So that is why we did not move for a motion for a new trial at the trial stage.
But you'll agree we know you'll agree we know nothing about counsel's thoughts on the matter, whether he was making strategic decisions, and we also don't have any findings from the judge who was there, who would know what effect, if anything, these claimed errors or omissions would have had on the outcome of the trial.
Yes, Your Honor. I do understand that. When I discussed it with my client, and we believe this is the best we could have done for this trial. So the first thing I would like to discuss in the ineffective claim, which I would argue is the most apparent in the ineffective claim, when the defense attorney starts asking questions during his case, during cross-examination, and he asks the questions which result from the victim saying he was on probation. He was on probation. So when he first asked that, he goes to the sidebar, and it almost seems as though he almost apologizes to the judge. He says something along the lines of, I didn't intend for that to happen, but I'll follow my sword and move on. The very next question he asks it again, then he asks it again and again and again. And then eventually he elicits that the victim says he came out of jail. This is ineffective because first, the jury now knows that the defendant has been on probation and been in jail. They're no longer focusing on the current conduct of the defendant. Defense attorneys now open the door to more prior bad acts. He seemingly apologized to the judge. I know he didn't say I'm sorry, but if you read in between the lines, I believe that's what he's trying to say. He's denuded the defense by give it not a fair trial. He's opened the door to more prior bad acts. And he's asked this question 5, 6, 7 times in a row for no apparent reason. I would argue there's no strategy could make this a good strategy. Having the jury know that your client has been in jail, been on probation, and asked this many different times.
Even if we were to conclude that presents a clear case of substandard performance, isn't it necessary also to evaluate prejudice? And isn't the trial judge in a better position to do that in the first instance?
Normally, I would say yes, Your Honor. But in this case, I would say the prejudice is very apparent. This is not a case where a trial attorney, brings it up. It happens one time. It happens 6 or 7 different times. Repeatedly ask this question, and I would believe, Your Honor, that there's severe prejudice because he keeps on asking the same question. And now the jury is sitting there thinking to themselves, what else has this defendant done? He's been in jail. He must be a bad guy. The next issue in the ineffective claim that we'd like to discuss is when he starts talking about hearsay versus impeachment. During his case, he tries to get the ex-wife to present almost of an alibi. The judge keeps on asking him, how is this not hearsay? And he keeps saying things such as, I'm not too sure. I had to go back and look at that. And I have to go research the rules of evidence to refresh my memory.
Well,
He doesn't ask for
admittedly, he was fumbling around there, but unless you can show that a more effective response actually would have succeeded in getting the information in, then what's the prejudice?
what I'm going to do when I wrap up, when you look at all of these issues, maybe one in and of itself might not get me there. But if you look at the 6 or 7 different issues in an ineffective claim, it's going to show that when you take all of these together, there is definitely an ineffective assistance of counsel here.
Right, but to add them up, you need to show, before we decide what we're going to add up and consider in the aggregate, we need to be satisfied that these incidents or instances of ineffectiveness that you point to actually did have some prejudice, even if individually the amount of prejudice might not be enough to order a new trial. So on the hearsay issue, what could more competent counsel have accomplished?
So what should have happened, I know this is a little bit of hindsight, was he needed to ask the victim about this incident first in order to impeach through his witness. He did not do that. And with this, the defense that denuded the defendant was it stopped him from showing that the plaintiff witness was not telling the truth, that she could have been impeached. This did not allow him to have an impeachment jury instruction, anything of that nature. Yes.
I got the sense that the judge knew what was going on here when he asked, isn't this hearsay?
Correct.
And because what was proposed was hearsay, you cannot call a witness to impeach someone with hearsay.
Correct.
So the chosen avenue was dead on arrival.
Correct.
There wasn't a legal way to do this.
No, I would agree with that, Your Honor.
So it's not ineffective for not doing it.
So maybe to make my point exactly clear, but so what I'm trying to say, Your Honor, is because he didn't do it properly in the beginning stage, it was hearsay. It stopped any possibility of.
I'm sorry to interrupt, but he could not do it within the rules of evidence. So the fact that the judge stopped him does not render him ineffective.
Put it this way, what could he have done differently with the victim that would have set up this testimony from the ex-wife to be proper?
He needed to ask the victim those questions in order to get the answer. And then what he should have done was, during his case, when he questioned the ex-wife, get her response to create some form of impeachment, to give the jury the idea of there's 2 different stories and which story should we believe. He never did the first step, which was ask the questions from the victim, which I believe the judge said that at one point, says, you have to ask the victim what those questions were. You failed to do that. So therefore, the questions you're trying to ask right now considered hearsay. The next step, I know I'm almost out of time, so if it's pleased the court, just want to spend a very brief moment on one of the issues, which was, excuse the word in here, is the vulgar words and witness intimidation. The first one, I'm going a little bit backwards, is when he states, the baby's going to hate you if you put me in jail. I think the court erred by not entering a required finding of not guilty, because that statement, my baby's going to hate me if you put me in jail, is nothing more than just words. There's no fear there. And the victim was allowed to go outside, allowed to go with her friends. It's a hypothetical issue here. It's not witness intimidation.
But we're not viewing that statement in isolation, are we? The whole incident on April 22nd involved more than that, asking where the phone was and I think commenting that she was always hearing from him that she's not a citizen, that she can't get custody. Don't we have to consider that as well?
No, I do understand that you don't look at the, from the case law, yes, you do look at the whole type of circumstances. We're saying even when you do look at all those circumstances, I still don't believe that gets you over the hump. That statement should not equal witness intimidation. No amount of time. And if there are any other questions, I would rest my brief, Your Honors.
Seeing none, we'll say thank you. Mr. Yakov.
Thank you, Your Honor.
Thank you, Your Honor. Good morning, Your Honor. May it please the court. My name is Konstantin Tretyakov from the Middlesex County District Attorney's Office. I represent the Commonwealth. I will start addressing the issues in the order my brothers raised them in his oral argument. As to the sufficiency of the evidence on assault and battery with a dangerous weapon, to wit, Wall, under the Lattimore standard, all evidence must be viewed in light most favorable to the Commonwealth, and the inferences that the jurors draw from that evidence do not need to be inescapable. They just must be reasonable and possible. In this case, the trial evidence established, and this can be found on page 153 of the first volume of the trial transcript, that the defendant pushed the victim towards the wall as she was standing near the wall, and the victim, unsurprisingly, did hit the wall with her head, and that caused her to fall on the floor. Now, the assault and battery with a dangerous weapon in Massachusetts is a crime of general intent. There is no need for the Commonwealth to prove that the defendant intended to use the wall as a dangerous weapon. In fact, the appeals court and the Supreme Judicial Court of Massachusetts have addressed this issue several times. These cases are cited in our brief. The case most on point, I think, is Commonwealth against Lefebvre, which is, as I just mentioned, is cited in the brief for the Commonwealth, where the victim was pushed into the concrete chute above the aqueduct of some sort, I guess. And in that case, he was charged and convicted of assault and battery with a dangerous weapon, and the court specifically said there was no need for the Commonwealth to prove that the defendants intended to use the wall as a dangerous weapon. But even on the defendant's own theory in this case, pushing the victim against the wall with the victim standing nearby the wall clearly supplied very reasonable and possible inference that the defendant intended the victim to hit the wall. So even on the defendant's own theory, that argument fails. Unless the court has further questions, I would like now to turn to the issue of ineffective assistance of counsel. The court in this case is without the benefit of the trial judge's ruling on a motion for a new trial, and at the very minimum, on that motion, there would conceivably be an affidavit of trial counsel explaining his trial strategy and the assessment by the trial judge of the averments made in that affidavit based on the judge's memory of what happened during the trial. The defendant also does not tell the court on appeal what is the substantial ground of defense that the allegedly inappropriate or ineffective behavior of his counsel deprived him of. So that is also a reason to reject that claim. As to the specific issue with respect to the hearsay evidence through the ex-wife. It was inadmissible hearsay. It was offered for the truth of the matter asserted. As to the defendant's argument on appeal that the defendant could have accomplished more by asking the victim, that is based on surmise that the victim would have provided some sort of inconsistent statement with which the ex-wife's statement would be inconsistent with, but that is just speculation. And as to the defense counsel during the trial saying that he opened the trap, if the court looks at the trial transcript, that was actually the line of questioning that led to these admittedly unfortunate for the defendant responses from the victim, was part of trying to undermine the victim's credibility by asking her about her interactions with the police officers and trying to establish the inconsistencies between what the victim testified to at trial and what she told to the police officers on the day she interacted with them. That is a reasonable trial strategy. And again, this court and the Supreme Judicial Court emphasized many times that hindsight is always 20/20, so to speak, but the assistance of counsel should be viewed without the distorting effect of hindsight. And the question is whether or not the strategic decision was reasonable or not whether or not it yielded the results that defense counsel was hoping it to yield. Turning now to the issue of the sufficiency of evidence on the witness intimidation. Contrary to what my brother has just suggested, the intimidation charge was not based on the fact that the defendant was saying that the victim was not a citizen, that she could not take the custody of the baby. There were two witness intimidation charges on March 17th and April 24th of 2018. On March 17th, after violently beating the victim, hitting her against the wall, causing her nose to bleed, pulling by her hair, the defendant is calling her cop collar, and then the expletive, which I probably should not repeat in the open court, and specifically telling her, do not call the cops. That, viewed in the context of the relationship between the defendant and the victim, provided the jurors, again, in the light most favorable to the Commonwealth, with a reasonable and possible inference that the defendant was trying to intimidate the victim from calling the police, which he ultimately succeeded doing, although that whether the defendant has succeeded or not is not an element that we have to prove. So that statement, don't be a cop caller, do not call the cops, was clearly purposefully intended to put the victim in fear from calling the police. By the same token, on April 24th, after beating the victim, after she locked herself in the bathroom, the defendant starts yelling at her and asking her, where is your phone? Where is your phone? And the victim tells him, she testified to that at trial, the phone is not with me, I'm not going to call the police. So that repeated question, again, taken in context with his remarks about her not being a citizen, that the baby will hate her if she puts the father of the baby in jail, that she will not get custody of the baby, taken together with the history of that relationship, and again with the violent beating that the defendant subjected the victim to on April 24th, which included squeezing her neck and ripping her dress, that provided the jury again with a reasonable and possible inference that he was doing that with the purpose to intimidate the victim to prevent her from calling the police officers. As to the issue of closing argument, just very briefly, the prosecutor properly commented on the evidence and marshaled the evidence in the light most favorable to the Commonwealth, which she was allowed to do. Her comments that the victim was straightforward and candid were based on the evidence, and the prosecutor actually gave the jury the specific instances which she based that conclusion on. As to allegedly excluding the evidence of the defendant's ex-wife, if the court reads the relevant paragraph of the closing argument. In the very first line of that paragraph, it's very clear that the prosecutor was only talking about the evidence for the Commonwealth, which she correctly concluded was the photographs, the victim's testimony, and the testimony of the police officer. And finally, on the prior bad acts, there was no abuse of discretion in admitting them. The judge gave a very detailed and thoughtful explanation as to why these acts were admitted. She only admitted 2 instances of the prior bad acts, and of those instances, only 1 was heard by the jury, and she also limited the scope of the bad acts. That's all can be found on pages 56 to 65 of the trial transcript, so there was no abuse of discretion in that respect. Unless the court has further questions, the Commonwealth will rest on its brief.
Seeing none, we thank you both.
Thank you, Your Honor.
We are live and on the record.
Thank you, Patricia. Welcome to the Appeals Court. I am Justice Meade. With me today on the panel are Justices Sullivan and Sachs. We're going to do our best to keep this as normal as possible. If for some reason you have a technical difficulty, don't worry, we'll reestablish a connection and you'll be able to give your full argument. Each side gets 15 minutes. You needn't use all of your time. We've read everything, and with that, I'll call the next case, 2019 P56, Commonwealth versus Taylor. Ms. Jellison.
Good morning, Justices, and may it please the court. Eva Jellison for Mark Taylor. I'd like to spend most of my time today on the erroneous instruction and the failure of the jury to agree statute. If I have time, I'll address the Debene knife and the bomb threat, and of course, I would be happy to answer your questions on any issue. Starting off with the judge's instruction, the Commonwealth concedes that the judge's instruction was error. And specifically, the error was that the judge instructed that a knife is a per se dangerous weapon when she instructed on the unlawful entry element of home invasion.
So if the judge had left out that one sentence, would the instruction be proper?
Yes, it would have been proper except for that sentence.
Okay, so in that case, do we look at the issue for the jury would have been whether the weapon was dangerous as used once Mr. Taylor was inside?
So I don't think that's the proper inquiry. This is a temporal element, and I'd like to point the court to a footnote in Commonwealth versus Mahar to illustrate this point. In footnote 6 on page 652 of Mahar, Mahar describes a case called Commonwealth versus Fleming out of this court, and I'm just going to read the footnote. Thus, while the defendant's subsequent acts of beating one occupant and drawing his pocket knife on another were unlawful, a jury could find that his initial entry into the dwelling was not. The crime of armed home invasion is not intended to encompass situations where an invited guest in a home suddenly turns violent. So I don't believe that this is about whether or not the knife was ultimately used as a dangerous weapon in an assault and battery with a dangerous weapon, that type of inquiry, which we see in Commonwealth versus Delaney, and I think another case cited by the Commonwealth that was unpublished. What we're looking at is whether or not the pocket knife, or any knife actually, was a dangerous weapon when Mr. Taylor entered the apartment. And I think you have to look at it in that temporal space.
Well,
so
how do you deal with the Commonwealth versus Bois case cited by the Commonwealth 476 Mass 15, which comes after Mahar, and which involved essentially the same error as involved here? And the SJC said, thus the jury should have been instructed not that the knife was inherently dangerous, but that they must determine whether it was dangerous as used.
Yeah, and I believe that at the time of entry, it wasn't being used. It was concealed on or could have been concealed on Mr. Taylor's person. I acknowledge that there was some evidence that he came into the apartment wielding the knife, but there was also evidence that if he had a knife at all, it was concealed on his person. And I think that that is illustrated in the case law, and that you have to then look at the second element of unlawful entry, which is whether or not Mr. Taylor intended to commit a crime within.
Can I, help me out, what's the import of whether it was concealed or not?
I believe that you could find that someone that was wielding a knife pointing it at someone's eyes, pointing it at someone's neck, was actually using the knife. It could be dangerous as used if it were wielded during the entry. So looking at
How could it be dangerous as used if he stabbed three people several times?
It could be dangerous as used, but I believe that the way that you have to analyze this, and the public policy would favor this, because especially where our laws surrounding dangerous weapons, a shoe can be a dangerous weapon, a plastic toy could be a dangerous weapon, and you could have any of those items on your person when you're invited into a residence, and then further circumstance could occur and you could assault someone with that plastic toy or your shoe or a ring, and it wouldn't be that you entered the home with a dangerous weapon and could therefore be charged with home invasion. It should be that you entered the home consensually and thereafter committed a crime.
I don't your hypothetical is a much more difficult case for the Commonwealth, but I think we know that these folks didn't accidentally happen upon Mr. Bastaracci's house. One of them had bought crack from him before, and they formulated a plan to go back and rob him.
So the evidence is really in dispute on that point. There are three people. The testimony comes from a lot of different sources. Ms. Cofield testified that they had a plan to rob, but the jury also heard that Ms. Cofield only stated that after she had been offered a cooperation agreement by the government. And Ms. Cofield was high during this incident. Mr. Taylor testified that he went in intending to purchase drugs from Mr. Bastarch. There was corroborating evidence for that. Mr. Taylor said that he gave Mr. Bastarch $300. When Mr. Bastarch arrived at the hospital, he had $334 in his pocket. Mr. Bastarch testified that Mr. Taylor struggled with him at the threshold and wielded the knife. That's contradicted somewhat by the video evidence, which is objective, where you can see Mr. Taylor walk slowly up to the landing on which Mr. Bastarch's door was, and then walk into the apartment. You don't see a struggle. You don't see heels ground in, that type of thing. You can only see his shoes, but it appears that he walks into the door. So the evidence was conflicting on this point, and the jury could have believed some, none, or all of each of the witnesses' testimonies. And where we have a cooperating witness, the defendant who clearly has some self-interest, and the victim whose testimony is contradicted by objective evidence, who was high during the encounter and who ended up with very serious injuries and may not have remembered everything.
You know, the evidence may have been in conflict on what their intent was when they entered the apartment. What Taylor and Martinez, was it, his co-defendant? Yes. But I'm still not understanding why the dangerousness of the weapon has to be, or not, has to be determined as of the time they enter.
I think it's exactly the footnote in Mahar. The crime of armed home invasion is not intended to encompass a situation where an invited guest in the home suddenly turns violent. So if I carry a pocket knife...
Okay, go ahead. I'm
looking at the footnote. So if I carry a pocket knife, which is not dangerous as possessed, many people carry pocket knives. If I carry a pocket knife into a residence, and then I have a dispute over a drug transaction, and I then choose to commit the crime of assault and battery with a dangerous weapon, so be it. I can be convicted of assault and battery with a dangerous weapon. I could be convicted of armed robbery if I thereafter commit an armed robbery. But I shouldn't be convicted of home invasion because I did not possess a dangerous weapon when I entered the apartment, and I didn't have
Why wasn't it dangerous? Because it was used in a dangerous manner once inside.
It was used in a dangerous manner once inside after circumstances changed. A pocket knife or another type of knife that's not a dagger or a stiletto is not dangerous per se, and it's not dangerous as possessed.
So this wasn't objected to, right? So
this was not objected to. It's substantial risk of a miscarriage of justice.
To establish a substantial risk of a miscarriage of justice. Why isn't this case like Delaney, when there was exactly the same erroneous instruction, and the SJC said because the victims were stabbed multiple times, there was no substantial risk on the question.
Delaney involved an armed assault with intent to murder, or armed assault with intent to kill. And the elements are simply different in that case.
Not as far as the dangerous instrumentality, they're not.
If you, in that case, the dangerous weapon that the The elements are so different. They don't have this temporal
They both
component,
require
and
the
they
use
don't
of a
have this.
dangerous weapon, right?
Excuse me?
They both require the use of a dangerous weapon, right? So
They do, but
and it's one that, excuse me, it's one that's either inherently dangerous or dangerous as used, right?
yes.
Okay. And so in that case, what the case turned on was the erroneous instruction on whether, when the judge said a knife was inherently dangerous, the same instruction that was given here. And the SJC said it did not create a substantial risk because they were they inflicted multiple stab wounds, which is exactly what happened here.
Yes, and armed home invasion also includes an element of using the dangerous weapon. But that's not what I'm talking about here. If you look at the element of use of the dangerous weapon, there was potentially stabbing. But I'm looking at the element of unlawful entry, and the policy around it that the SJC has announced.
Maybe I missed it. Did you claim the judge instructed improperly on unlawful entry?
Unlawful entry only, yes.
That she misinstructed on unlawful entry.
She misinstructed on unlawful entry because dangerous weapon is a component of unlawful entry.
Oh, I see.
So only as to unlawful entry. That is the only element that I can test. And what I'm saying is that where she said that a knife is a per se dangerous weapon, that she effectively instructed the jury on unlawful entry, that if they believed Mr. Taylor had a knife, they didn't have to struggle with his intent to commit a crime within. And if they had struggled with his intent to commit a crime within, there were disparate facts, as I've discussed. And this was a very thoughtful jury. The Commonwealth pointed out that this was a very thoughtful jury. They acquitted each defendant of some of these offenses. And I think that if they had to struggle with this, they may have seen this as a case where he didn't intend to rob anyone when he went in, but circumstances changed, and then he committed armed robbery or assault and battery with a dangerous weapon. So I think the fact pattern is consistent with that. And since the jury really didn't have a choice, the judge told them they could find unlawful entry. There is a substantial risk of a miscarriage of justice here because there's a substantial risk that the jury might have found differently. Just as, it doesn't have to be that the jury would have definitely found Mr. Taylor not guilty. It has to be that there's a substantial risk that they might have found Mr. Taylor not guilty. And I think that where the judge essentially gave them the answer to one of the elements, said, if he had a knife, it was an unlawful entry. It might have been different if it was, did Mr. Taylor have the intent to commit an assault within? And there was very varied evidence on that from witnesses with different credibility problems. If there are no further questions on that issue, I would move to the verdict issue. So I think the question for the court on this issue is whether Note J constituted a return under the statute, and that is General Law 234A, Section 68. So Note J did constitute a return. The note itself says, after rigorous deliberation, we have arrived at a verdict of 11 of the 16 counts and are unable to arrive at a unanimous verdict on the remaining counts. And the court has said
the statute involves not only a return, but also involves being sent out to deliberate again. And nothing occurred based on Note J that constituted the jury being sent out to deliberate again. So I don't see any element of coercion here, such as the statute is designed to protect against. The jury, came back in with another note. I shouldn't say came back in, but sent another note, which in essence said, oh, maybe, we were premature when we said before that we were deadlocked because we went on, we didn't hear anything. We went on discussing and deliberating, and we've reached verdicts on 5 out of the 6 remaining counts.
I would just disagree with one characterization that you made, that the jury didn't hear anything. They did hear something. The judge instructed the court officers after Note J to tell the juries to seal the verdicts they had already come to, and the jury thereafter continued deliberating. In the sense that they didn't come back into the courtroom and get sent out. No, they didn't get sent back out to deliberate. But if you take a larger view of that, where the judge gave them some instruction, didn't instruct them to stop deliberating, I believe that was a being sent back out to deliberate. She told them to seal the verdicts they had already come to. I think that it was implicit that they could continue deliberation on the remaining counts. So I believe that that was sending them back out to deliberate. And then there's no dispute that note K was a return. The Commonwealth doesn't dispute that. So it really is whether or not note J was. And I guess I would just point out that that was certainly after due and thorough deliberations. It was after 10 hours of deliberations from a case that had 4 days of evidence, included 12 witnesses and 26 exhibits. And if you compare that to other cases that this court has done a due and thorough deliberations analysis on, it's really different. There was one where
let me ask,
Absolutely.
do you agree that the standard of review is whether the judge abused their discretion in deciding whether note
I
J was a
do
return?
not. No, I don't believe that this is an abuse of discretion. I'm not challenging whether or not she gave a proper Tui Rodriguez decision. That would be abuse of discretion. I'm sorry, instruction. That would be abuse of discretion. But this statute is very clear. They shall not be sent out again without their own consent. That does not indicate that
Okay,
this
if there have been due and thorough deliberations, but and the
Yes.
Commonwealth in its brief cites the Jenkins and Maine cases from our court,
Yes.
saying that it's not till a judge determines as a matter of discretion that the jury's deliberations have been due and thorough that a jury's return counts under the statute. So that's why I'm asking.
There is an element of discretion as to whether or not the deliberations have been due and thorough, but there would be no discretion to send the jury out anyway if there have been due or thorough deliberations. And
So
I don't
you're saying
believe
it was an abuse of discretion in determining that note J was not evidence or did not establish due and thorough deliberations?
Judge Kenton Walker was never asked to whether or not note J had constituted due or thorough deliberation. So I believe that this court on the record can determine whether or not, if you determine that note J was a return, which Judge Kenton Walker didn't consider, and you determine that there were due and thorough deliberations up to that point, it's not really looking at Judge Kenton Walker's decision. It is an issue of fact that this court can determine.
Unless there are other questions, your time is up.
Thank you very much.
Seeing none, Ms. Haran.
Thank you. May it please the court. My name is Donna Marie Heron, Assistant District Attorney representing the Commonwealth. I'll go to the first issue first. We are conceding that the judge erroneously instructed the jury that the knife as used was a dangerous weapon. But it clearly did not create substantial risk of a miscarriage of justice where there was overwhelming evidence that the defendant and his co-defendant stabbed the victims multiple times. Indeed, I believe Mr. Basharas was stabbed 8 times. The Salve was stabbed 2 times, and Mr. Curran was stabbed 1 time. In the case law under Commonwealth v. Delaney, under Commonwealth v. Boyce, which I would actually ask this court to look at, which is an SJC 2016 case, and in that case was an armed home invasion. And the court there found that the pocket knife used there was not a dangerous weapon, and it used the Delaney case to actually contrast it because it said the knife, there's no evidence of how the knife was used in that case. While in Delaney, there was clear evidence that the knife was used to cause serious bodily injuries by stabbing the victim multiple times. So therefore, I would suggest that they clearly, based on the overwhelming evidence that the victim suffered multiple stab wounds, that there was no substantial risk of a miscarriage of justice.
What do you say to the argument that the defendants had to have, if I understand the defendant's argument correctly, that there had to be some intent to use the knife in that fashion at the time of entry?
I would suggest, Your Honor, it's clear, and I ask you to look at Putnam case and also the Mahar case, that at the time of for armed home invasion, they have to be armed with a dangerous weapon, which I suggest the way they use the knife clearly was as a dangerous weapon. And for it to be an unlawful entry, the occupant of the dwelling has to either not know that they are armed with a dangerous weapon or not know that they plan to commit assault while inside. And I would suggest the evidence showed, based on the evidence the jury found credible, that the defendants came up with a plan to rob the victims, and they were armed with a dangerous weapon and went through and entered the home with that plan. And I would suggest that there was overwhelming evidence of that. The only evidence to the contrary was Mr. Taylor's testimony, which I suggest was not believable and the jury did not believe.
Does your argument depend on the jury having found that they entered with the intent to rob, or are you arguing that the fact of entry with the knife and its later use in a dangerous manner is sufficient to establish lack of consent to the entry?
I would suggest the entry with the knife and the use of it later on to stab the victims multiple times establishes that. based on the Delaney case, the Boyce case, and the 128 that I submitted along with my brief.
I take it that you're also arguing that if they came in with the intent to rob and were armed for purposes of making sure that they were successful, that is the necessary proof at the time of entry, and that can be inferred both from the plan to rob and from the subsequent use of the knife.
Yes, Your Honor, I am. If there's no further questions on that issue, I'll go to issue 4. And on issue 4, my apologies, on issue 4, it's clear that the judge acted well in her discretion to give the Tua Rodriguez instruction after receiving the 3rd jury note. And I'd like to go to the transcripts that discuss that. And it's when the judge at 2 o'clock is talking with the parties and says that she received one note the jury sent at 12:50, but she didn't receive it right before lunch. And she said, quote, "I instructed the court officer to tell the jurors to take all the verdict slips they have reached a verdict on and seal them. And because we're at the lunch recess, I looked for counsel and wasn't there, and we'll address the question at 2. It's clear that is not a return under our law. It's clear that the judge wasn't instructing them to continue to deliberate since they're on a lunch break. And it's clearly they're on a lunch recess. The fact that the jury on their own decided to continue to deliberate and come to 4 more verdicts and then came back at 2 o'clock and said they were only at an impasse on 1. And then it was then that the judge, in her discretion, found that they had deliberated due and thorough deliberations, and she counted that as the first return. And again, the defendant did not object at that time. The defendant agreed with the judge's assessment of the situation and then agreed that the judge should then give the Tua Rodriguez instruction. Then the jury came back a little later with their verdicts. I would suggest this has followed the law as it is under 234A 68C. I suggest it's abuse of discretion because it's the judge that first determines whether they have deliberated due and thoroughly. That counts as a return under the statute. And she did do that, and the defendant did not object at that time. And then she sent them back and they came back with a verdict. And I would suggest that, oh, I'm sorry, Your Honor.
Yeah. Note K starts out from the jury starts out update on previously unanswered question, referring back to note J. So what should we conclude from that phrase, update on previously unanswered question? Did the jury not receive the message from the court officer to seal the verdicts and wait till 2?
To be honest, Your Honor, I didn't notice that, but I guess even if that is the case, that they didn't hear anything, there was no communication, so therefore there was no return under the statute, because the statute is to prevent and safeguard jurors from being coerced into reaching a verdict, and I think clearly here, when they decide on their own to continue to deliberate, there's no coercion. If there's no further questions on that issue, the Commonwealth would just like to add one detail. Around 4 o'clock on Friday, the Commonwealth received, I'm sure the court received, a 16L letter by the defendant citing Commonwealth versus Arrington. And I would just like to alert the court to know that that case was actually overturned by the SJC on further appellate review by, and the site is 390 Mass 875. And the SJC took up the Commonwealth's further appellate review on that case, and they overturned the appeals court decision. I just like to note that for the record.
Was that on what basis did they overturn it?
Briefly, the case involves the child abuse where the defense counsel was cross-examining the victim and asking her why she continued to babysit for the defendant's children when she claimed to be abused. And during that, the victim eventually said because another victim had come forward and said she was abused, and defense counsel objected and asked for a limited instruction. And the judge said no at the time. And they continued on with the evidence. And then later on, the judge then, after a few more witnesses, said they decided to strike the evidence and give a curative instruction. And the appeals court found that curative instruction did not cure the prejudice. And on further appellate review, the SJC actually found that that wasn't an error, that the evidence was admissible because it allowed the defense left an impression that the victim wasn't abused and she continued to babysit for the defendant. And the only reason
it's sounding like the SJC did not say that the striking of the instruction given at the time the evidence was stricken was sufficient to avoid prejudice, which is the purpose for which the defendant cites Arrington here.
Well, the jury said They returned it because there was no error, so therefore there was no issue with the instruction because there was no error for the evidence to get admitted. So therefore the judge wasn't obliged to give a limiting instruction because there was no error in the admission of the evidence, and that clearly the defendant couldn't have been prejudiced by any instruction because the evidence was properly admitted.
Right. So it's not a case about when evidence is properly stricken, how strong the instruction to the jury to disregard it has to be.
It just said that the evidence was properly admitted, so therefore any limiting instruction wasn't warranted, and therefore there was no error. I just wanted to point that out for the court. If there's no further questions, the Commonwealth will rest on its brief.
Seeing none, well, thank you both.
Thank you very much.
We are live and on the record.
Welcome to the Appeals Court. I am Justice Meade. With me this morning are Justices Sullivan and Sack will be the panel for this case. Each side gets 15 minutes as usual. You need not take all of your time. If there's some sort of technical glitch, don't despair. We'll do our best to get things back online to hear your presentation. With that, we'll call our next case 2019 P 1561 Commonwealth versus JOSEY. Ms. Oren.
Thank you very much. Good morning. I'm Catherine Oren for Benjamin JOSEY. And if I may, JOSEY is keen to stress to this court that he is innocent of all charges. And if I may stress two principal concerns this morning, that would be great. First, conviction for armed robbery here meant proving beyond reasonable doubt a knife or something a reasonable person would have taken for a knife. But no evidence suggested any facts about whatever thing Benjamin had purportedly held in his hand. Even basic shape was wholly undescribed. Nothing suggested it was long or narrow, or even that it was longer than it was wide.
Excuse me, Ms. Oren, excuse me, didn't the victim say it was a knife?
He said that the full relevant testimony was factually groundless conclusory conjecture. What he said is, quote, "It ought to be some sort of folding knife," end quote. And he didn't say anything about it. You know, it was this thing, and he's looking for a blade and he didn't see anything. And the problem here is that factual void reduced elemental fact finding to open witness vouching. His testimony reduced to, take it from me, based on out of court facts I've just told you about, it must have been some kind of knife.
Isn't that a question of credibility?
No, it's a question of
credibility?
No, it's a question of he for facts that no one knows why, he thought it ought to be some sort of folding knife, even though he couldn't see a blade. He couldn't state the shape. He couldn't state anything about what the thing was made of, that it was any substance that was consistent with a knife, or how it was constructed, that it had components consistent with a knife. There was nothing like that. It was this conclusory declaration, quote, "It ought to be some sort of folding knife." But again, that's just, we don't know, no fact finder would know even one thing about that object from which a person could draw, proof beyond reasonable doubt that either it was a knife or something somebody could have reasonably mistaken for a knife.
Well, Ms.
And
Oren,
it's on that ground.
Ms. Oren, the victim actually said that he displayed the knife and the defendant said he was looking to rob somebody.
Well, he didn't call it. He didn't say he thought it ought to be some sort of knife. He pulled a knife and said, "I'm out to rob somebody." He pulled something. He held it in his hand and he showed it to him. And that it's not on the video and no one else saw anything. And so there's really no telling if there was something there, what it was, what about it factually would give rise to reasonable inference. It was a knife, and was there for that reason. There's no proof beyond reasonable doubt that he did in fact have a knife. And it's on those grounds that armed robbery evidence elementally failed.
May I ask, Ms. Oren, in both cases, two places in that paragraph of the victim's kind of lengthy answer, first he says, "What I saw ought to be some sort of knife." I'm wondering whether saw ought to be was actually the transcription error for saw to be. And similarly, at the end of the paragraph, the victim says, "He set out what I sought to be the handle of a knife." That's a very unnatural sentence construction. Could
It is.
what I
And
saw
he-
to be the handle of a knife really have been the victim saying what I saw to be the handle of a knife?
Well, that's speculation. I mean, he does use language in an unusual way generally. And I just urge that it looks like it is a conjecture here. It ought to be, it sought to be. He thought it was. He couldn't find the blade, but it's clear he thought it was. And the concern here is that there's simply no facts in evidence about the thing that would make such belief reasonable, much less reasonable, beyond any reasonable doubt. And that's the concern about vouching. It's just, I didn't tell you any facts about that thing, and I saw it out of court. So based on those out of court facts that I haven't told you anything about, take it from me, it must have been some kind of knife. And that's the concern here. And that's why JOSEY is urging that armed robbery evidence elementally failed. The other big concern is about harm done to reliable fact-finding by barring missing witness inferences. The Commonwealth itself stressed that Rio's father and brother had forced prosecution. And that was despite Rio's denial at the time that any robbery had occurred, along with video evidence, eyewitness testimony too of a cordial exchange before and after ATM use. So contemporaneous evidence disproved claim robbery. Rio's father and brother alone had witnessed angry family events that had forced weeks belated contradictory report to police. They were sympathetic to prosecution they had forced. They had no criminal history risking impeachment. They're crucial to credibility assessment, yet the Commonwealth removed them from scrutiny, and jurors were rightly allowed to draw all reasonable inferences from those absent witnesses. Now the court in Commonwealth claimed
what testimony, Ms. Oren? What testimony could the father and brother have been expected to give that was of distinct importance to the case and that was admissible?
Right. Well, their testimony had nothing to do with any robbery. The claim here is that they could only have offered hearsay, but they would rather have explained the crucial testimony. How did we go from at the time of this, encounter outside Tent City, where no robbery, did you buy anything? Were you stupid enough to fall for that? No,
if you could, of what one of them could have said that would have been of distinct importance to the case.
Well, what happened during those angry family communications that had changed that account at the outset into 12 days later, he's going to police and claiming he was robbed at night.
So they could have said what they said to the victim. They could have testified to that, but they couldn't have testified to what the victim said back to them. In other words, they couldn't have testified, oh, the victim didn't want to go to the police because he was really in doubt as to what had happened, but we insisted, and finally he agreed. That would have been hearsay so far as it have reported what the victim said, wouldn't it?
Only if it's offered for the truth of the matter asserted. So they definitely, what's essential is what did they
What else would it have been offered for?
Well, it would have been offered what influence came to bear during those 12 days separating this apparently cordial exchange even after ATM use to claim to police that this was an armed robbery. And they could have, what kind of anger, what kind of emotions, what did they see, what did they hear? If it's not offered to prove the truth of the matter asserted, but simply to explain, on the contrary, it's not being offered to prove the truth of the matter asserted. The question is, the victim himself stressed that there was no robbery. And so this is explanatory, purely explanatory. How did we get, of course not, I'm not stupid enough to buy something.
What would their testimony have explained? The victim's state of mind?
Right. What influenced the victim to change the account to actually going to police? Because even after he claimed to his cousin that, that was a robbery, and it wasn't that I was stupid enough to buy something, he had no intention of telling his family, security, police, or anyone. It was these angry communications after the fact with his father and brother that had forced prosecution. And that's the only reason that the jurors were in that room. So that's what they could have explained. What influences came to bear in those 12 days, specifically from the family, that changed the account so thoroughly, that's the only reason that the jurors are in the room. So that would have been the non-hearsay purpose. And the other thing, if I could note, is that the court is stating that JOSEY could have just called the witnesses himself, but that would have done no more than forced presence of hostile witnesses. And such witnesses aren't equally available to both sides. The ability to summon hostile testimony can't cure adverse inference born of removing key witnesses from jurors. And
Why
here,
weren't the father and brother available to the defendant? Why couldn't
well,
the
because
defendant have summoned them in?
they were adverse, and cases like Thomas, Nitsiolek, Franklin, Shotvet, if they're adverse, you know, they're not equally available, because all it would do is force hostile testimony. Whereas if the Commonwealth had put them on, there's no hostility, and it would then be the cleanest presentation of evidence. And here, the witnesses bore kin loyalty to Josey's accuser. They forced prosecution despite adverse video and eyewitness proof. This wasn't just weak evidence at the time of the purported robbery. It stressed factual voids supporting reasonable inference. There was some unpresented exculpatory proof. And the jurors rightly assessed non-presentation, along with the full range of inferences rationally drawn from that missing testimony. And so Josey is urging that reversal is mandated across the board, as is entry of judgment on elementally deficient proof of armed robbery. And Josey, again, is keen to stress to the court that he's innocent of all charges.
If I may, could you explain to me
Sure.
why it is that if the Commonwealth called these two witnesses and they gave testimony which you describe as hostile, subject to cross-examination, why is it so different that the defendant call them and subject to cross-examination on direct, the same testimony comes in?
Right. Well, they're not hostile to the Commonwealth. The whole point, they forced the prosecution. They were favorable to the Commonwealth. They bore kin loyalty to the accuser. They would not have been hostile.
I understand. Your point is that they're hostile to the defendant, but I'm not completely clear why that makes them unavailable to the defendant.
Well, that's under the case law. It's just that if they're not deemed equally available to both sides, if all the summons would have done is force the presence of hostile testimony, it just can't cure adverse inference born of removing witnesses to begin with. And this, again, the cases are in the brief. Shotvet, it goes back as far as Shotvet, Thomas, Nitsiolek. They're just not deemed equally available when they're pointedly hostile to the one side and not the other. And that's why it was proper. And so, again, if the court has no more questions, the Josey just is very keen to stress to the court, he didn't do this. He did not do this crime.
Thank you.
Thank you.
Mr. McLean.
Thank you, Your Honor. Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. This court should affirm the defendant's convictions for 3 reasons. The first, there was sufficient evidence of armed robbery presented where after twice asking for money and twice being refused, the defendant brandished what the victim understood to be a knife and said, "I am looking to rob somebody." Second, there were no missing witness instructions that were due here where the 2 non-percipient witnesses had only inadmissible hearsay to offer, so there was no reason the Commonwealth would have called them. And third, the trial judge did not err in ruling Detective Kelly could identify the defendant in the low-quality surveillance video based on his prior knowledge of the defendant unrelated to this case. So turning first to the sufficiency argument, this case really just turns on whether inferences need to be necessary. And they don't need to be necessary. They only need to be reasonable and possible. So here the victim testified that the defendant, after twice asking for money and twice being refused, then sat down next to him, became aggressive, displayed the handle of a knife, and stated to him, "I am looking to rob somebody." So from that series of facts, the inference that he is actively robbing the victim with what he showed, a knife, is a reasonable inference. Therefore, it stands and it's sufficient to establish the second element of armed robbery. Turning to the missing witness instruction, here the trial judge hit the nail directly on the head. Both the father and the victim had only inadmissible hearsay to offer. They had learned of the crime, the father third hand and the brother fourth hand. Then the conversations they had with the defendant afterwards, also inadmissible hearsay. So there's no reason the Commonwealth would have called them to the stand, making their testimony of no value. So there was no reason for us to put them on the stand. Also, the judge was correct in ruling that both of these witnesses would have been available to the defendant if he believed somehow this testimony would fit under a hearsay exception. I didn't hear one during opposing counsel's argument. The closest that I heard was maybe present sense impression, which is an exception that's just sort of not recognized in Massachusetts. So I don't see how there was any admissible testimony here. Turning to the third issue, which wasn't really argued today, but the trial judge's ruling on the motion in limine that was going to allow the detective to identify the defendant in the surveillance video footage. The trial judge did not abuse his discretion here. He cited the correct relevant cases. He cited Pleas, he cited Austin, and he evaluated the correct factors, and that he reviewed the surveillance video. He made what I guess we could construe as factual findings, that the video was both grainy and somewhat distorted due to the wide angle nature of the lens that was used. And that's at transcript volume 1, page 9. So he's evaluating the correct factors there. And he also evaluated how Detective Kelly knew the defendant from prior interactions unrelated to this case. So ultimately his ruling that Detective Kelly would be allowed to identify the defendant was legally correct. There was no error. But even if this court were to disagree and say there was some error in that ruling, there was no prejudice to the defendant. First off, the defendant conceded those facts in the argument on the motion in limine, that those facts were correct. So that negated the need for a voir dire of Detective Kelly. Then further, that there was no prejudice because the victim also identified the defendant as the perpetrator. You could see that at transcript volume 2, page 30, transcript volume 2, page 10, transcript volume 2, page 43. He also identified the defendant in a photo array as the perpetrator, and you could see that at volume 2, page 70.
Did the victim ever do an in-court identification in the sense of saying the man that is sitting over there at the defense table is the Benjamin who robbed me?
Not as clear as that, Your Honor, but that's the reason that it happened in that way. They didn't ask that final question was based on the stipulation that the judge had read to the jurors. So it would be redundant to point him out at that point because the stipulation immediately preceding the victim's testimony was the parties have agreed that it is the defendant in the surveillance video footage. And then during his testimony, the victim said, yes, that it was Benjamin that robbed me. So you put those two things together and it is the same thing. Also, it's the clearest aspect of him doing an in-court identification would be on cross, where he made it clear that he was IDing the defendant in the video. And I point you to volume 2 at page 43 for that. So here we have a situation where we're really close to Pina, the 2019 case, where other witnesses ID'd the defendant in the video. So this identification would have been redundant. And so there was no prejudice suffered, even if it had been error to allow it to occur. The second reason there was no prejudice here is that
he was essentially coerced into the stipulation.
Well, yes, I understand that, Your Honor. But so even if the court were to say the error was incorrect, the defendant or the victim was fully prepared to identify the defendant in court. So there's no prejudice. But even if you weren't willing to accept that as no prejudice, if you look at the second reason why there's no prejudice, it's the defense theory of the case. Their theory of the case was that everything happened except for the robbery component, that it was a consensual gift. So they were not contesting that the defendant was in the surveillance video at all. In fact, that was part of their defense. And you can see that from both their opening and their closing. Volume 1 at 140, and then in closing, volume 2, 83 and 89. Also in the motion itself, the motion in limine argument itself, they conceded that they were not contesting that it was the defendant in the video, which is transcript volume 1 at 6 and 7. So the whole motion in lim is sort of odd in that they conceded the factual basis and then they conceded that they were not even contesting that it was the defendant in the surveillance video here. But from our perspective, the judge did not err in allowing the detective to identify the defendant in the surveillance video footage. But even if the court were to determine that there was error, there was no prejudice here for two reasons. The first being, this would have been a cumulative witness identifying him. And second, it was not a contested fact. So there was no actual prejudice suffered by the defendant if the detective had been allowed to identify him. It seems that the defense was trying to avoid any testimony from Detective Keeley about how he knew the defendant, which is understandable because that basis of knowledge was based on the defendant having been a homeless sex offender. So it's understandable why they would have wanted to keep out the basis on which the detective knew the defendant in the case, which I think is probably the reason why they filed the motion in limine in the first place. So unless there are any further questions from the court, thank you very much, Your Honor.
Yeah, thank you very much. Thank you both. We'll take that under advisement.
Thank you. Thank you.
Good morning. Welcome to the appeals court. My name is Justice Meade. With me are Justice Sullivan and Justice Sachs. Will be the panel for today's case. Welcome to the appeals court. My name is Justice Meade. With me. Okay, someone has the YouTube page open. Needs to click.
Just mute it or shut it off, please.
We good? Okay. I'm Justice Meade. With me are Justice Sullivan and Justice Sachs. Will be the panel for your case today. If we have any technical difficulties, we'll stop and assess and probably cure and return to argument if necessary. This case, as you know, is impounded, so no names. With that, I'll call the case 2019 P850 John Doe 62427 versus the Sex Offender Registry Board. Ms. Green.
Thank you. May it please the court. My name is Ashley Green. I'm here today representing John Doe 62427. Just briefly, I'm sure the panel is familiar with the facts of the case. My client is now 49 years old. He is required to register as a level 2 offender, that is a moderate risk offender. These offenses occurred between the years of 1991 and 1999, and it has been over 20 years since my client committed any index offense. My client has no prior or subsequent criminal offenses, charges, or convictions on his record. The hearing examiner's decision had numerous errors throughout the decision, and today we're asking for a remand of this case to the hearing level and for a new hearing completely. The first argument that I would like to bring forward today is the second argument that was raised in my brief. And the reason why I bring that forth before the court for the first argument is because that argument is no question that this case needs to be remanded. In the case of Doe 496501, as the panel I'm sure is well aware, there are 3 requirements that a hearing examiner has to find with explicit findings in order to classify somebody as a level 2 offender. Those requirements are that the risk of reoffense is moderate, that the offender's dangerousness as measured by the severity and extent of the harm that the offender would present to the public in the event of a reoffense is moderate, and that public safety is realistically served by internet publication of the offender's registry information. In this case—
Can I ask you this? But you spoke in terms of mandates, but 496501 is to be applied prospectively, and the SJC said that we have the discretion to make the determination ourselves.
That is correct. The case is before the appeals court at the time that it issued 496501.
So it's not an automatic remand.
It is not an automatic remand. However, the case held that in some cases a remand may not be necessary if this panel finds that there are existing findings that are sufficiently explicit to enable a proper review, or that the underlying facts of the case are so sufficient that the finding that internet dissemination is required and that there's a moderate degree of dangerousness, that this court could make those findings. The case for my client is that there were no findings issued, explicit or otherwise. There was no mention of, during the discussion in the hearing examiner's decision, there was no discussion regarding internet dissemination at all. There was no finding.
But wouldn't that be the case in everything that was heard before 496501?
There were cases where hearing examiners were finding internet dissemination is required based on the underlying facts of the case. This was not one of them. This case, the hearing examiner completely omitted the finding or discussion of internet dissemination and just put it through as an automatic. And just last week, there was Doe 524553 that was issued just last week. And in that case, there was a remand because that hearing examiner found that they had no statutory authority to decide whether or not internet dissemination was required.
Which didn't happen here though, right?
That did not happen here. There was actually no mention of it here. So arguably even a worst case scenario where it's not even discussed at all, whether or not internet dissemination is required. And that case was similar to this case because that was also an interfamilial victim, which is this case. This was an incest-like offense. It was not a blood relative, but it was the daughter, a stepdaughter of his live-in long-term girlfriend. And that raises the question of if this is an isolated offense, how can a hearing examiner state findings that it is necessary to have the public put on notice of my client who has never once posed a danger to the public?
I'm not sure what you mean by isolated because he sexually assaulted this girl for almost 7 years.
The allegations were that it was from 91 to 99, isolated. And by isolated, I mean in terms of victim, in terms of victim pool. The idea that there's a broad victim pool goes straight to the concerns about the public. However, in this case, not only is this a small victim pool, it's a victim pool of one person.
Are you saying that the hearing examiner couldn't possibly find that internet dissemination is warranted in this instance? Or are you saying that we need to send it back to the hearing examiner because we can't make the decision ourselves, that the facts don't compel that result?
I'm saying both. My argument before this court is that this case needs to be remanded. However, in that same vein, as you'll see in my brief, the discussion and the analysis of the underlying facts of this case are simply that the facts of this case do not lend to any finding that the public was ever or will ever be in danger of my client because this was such an isolated offense, an isolated victim pool of one.
Don't you think that parents of children who live in Mr. Doe's community are entitled to know and can take measures to keep their children away from Mr. Doe's residence?
I do not find that under the facts of this case that the general public and the general pool of children and their parents are put at risk by Mr. Doe. He's lived 49 years. Only 10 of those years he was incarcerated. So he lived 39 years in the public and has never once offended or put any child at risk other than this one isolated incident, which he served 10 years for, and he is now serving a 15-year probationary period. And that also goes to the risk that he poses to the public because he, under those probation conditions, is prohibited from having any interaction with minors, and he is also prohibited from living with minors, which is a very strict probation condition. That means that even if he gets into a relationship with somebody that has a child, he is not allowed within these 15 years to live in the same household as that person.
He did have a girlfriend at one point, though, with a 15-year-old daughter whom he met. Did he?
He did. He did. There was never anything from that.
Is internet dissemination, I mean, and the record indicates that he told her about this, but is internet dissemination warranted for the limited class of the public that would include people who might end up in a relationship with him? Is that something the hearing examiner could consider in determining level 2 status?
That is certainly something the hearing examiner could consider. However, in the facts of this particular case, my client had a substantial number of witnesses at the first hearing testify on his behalf, and then he had about 18 letters of support written. And all of those letters, there was nothing in those letters that indicated that my client has ever been evasive about the facts of this case, that he's ever been evasive about the convictions in this case. that he is a sex offender. We also have to remember he has now been on the internet for years. So this isn't something that he is hiding from anybody in his life. I submit that there's no evidence to find that he ever would be evasive about the underlying conviction in this case. And if there were, then that is something the hearing examiner could use. Unfortunately, in this case, the hearing examiner made no findings regarding the dangerousness or the general public being required, or the general public safety being put at risk because they wouldn't have access to him or to his registry information. Again, this goes back to the argument that this needs to be remanded, because this court can't speculate on what could have been, but it needs to look at the record, and the record is mute when it comes to the required findings under 496501.
You asked alternatively for this court to reduce his level. I didn't know whether we could do that.
It's my understanding that this court, on the record, if it found that the evidence was insufficient to find a level 2, but that it may be sufficient for a level 1, low risk of dangerousness or low risk of reoffending, that it could reduce the level.
Wouldn't we have to send it back? I mean, this is a 30A review. We're not doing this de novo.
This is a 30A review, but the evidence can be reviewed as it is on the record. And the evidence is sufficient on the record that Mr. Doe would be a... Let
me ask it differently. Do you have a case in which this court or the SJC has reduced the classification without a remand?
I do not have a case in front of me where there has been a remand with a level 1 order, so to speak, but simply a remand. There are cases where they have specific instructions on a remand that
right.
That could be.
You're not aware of a case where the appellate court actually reduced the classification?
I don't have one in front of me.
What about 496501?
My understanding of 496501 is that it was, my understanding was that it was remanded to the board with specific instructions that the 3 requirements were met and found with explicit findings. But if that is not the accurate outcome.
Is there anything else you'd like to tell us?
With my remaining minutes, I would like to go to my first argument. Well, briefly, I'll touch on my last argument, argument 3, which is in reference to the hearing examiner abusing his discretion when he disagreed with the findings from an expert, Dr. Leonard Bard, in this case, an expert well-known to the legal community. In this case, Dr. Bard first evaluated my client in 2013. At that point, in 2013, Dr. Bard found that my client was a low-risk offender. 4 years later, that opinion was resubmitted to the hearing. It's my understanding my client did not get funds again to rehire Dr. Bard, but the evaluation was resubmitted. Now, it was now 3 years later, arguably with my client living an exemplary lifestyle, still going to sex offender treatment therapy, and also living by the requirements of probation, the risk would be even lower than that. And unfortunately, in this case, the hearing examiner decided that because Dr. Bard went above and beyond what the evaluation is by the board, he disagreed with Dr. Bard's findings. I argue
instead that he used different methodologies that didn't properly assess the factors. For example, the repetitive and compulsive behavior is nowhere discussed in Dr. Bard's report.
That's correct. Just because you brought up repetitive and compulsive behavior, factor 2, the science has shown it. And just last week, the decision that came down in 524-553 discussed this. Factor 2, repetitive and compulsive behavior, has been discussed by Carl Hansen, and it's been brought into many of these cases, that those finding of that factor has to be when an offender has been approached and there has been a charge, there has been some realization that he is offended, and he goes back and reoffends again. There has to be some break.
So that was Mr. Bard's, Dr. Bard's narrow idea of what that means. That's not been accepted elsewhere.
It has been discussed by Dr. Carl Hansen, and he is the person who wrote the articles that the board uses to support factor 2 as a regulatory factor.
But
So
those-
the board cites
Even though he wasn't sanctioned, he still had an opportunity to reflect on his behavior, did he not? Since it was over 7 years.
there over the 7 years, there is an opportunity to reflect, but in the case of factor 2, it has been widely discussed and analyzed and clarified by Dr. Carl Hansen, who was the expert that was cited to by the board's regulations. And he has said
So the hearing examiner abused his discretion for not crediting Dr. Bard's version.
the hearing examiner, I'm sorry, can you repeat that?
You're saying that the hearing examiner abused their discretion by not crediting Dr. Bard's assessment.
The hearing examiner abused his discretion, absolutely. And the reason for that is he said that Dr. Bard used different methodologies. Dr. Bard didn't use different methodologies. Dr. Bard used more substantial and overall covering all the bases. He also, not only did he go through all the factors and apply all the factors as the board does, so put that aside. So he did exactly what the board does. But in addition to that, he used 2 actuarial tools to assess the risk of reoffense and degree of danger that have been generally accepted, widely accepted in both the legal community and the scientific community. And I submit that the hearing examiner abused his discretion by saying that Dr. Bard used different methodologies. In the case of—
we understand your time is up.
And for that, it's 236656. Thank you.
Mr. Doyle.
Thank you. Good afternoon, Your Honors. Thomas Doyle for the Sex Offender Registry Board. Obviously, in 496501, the SJC knew that there would be dozens, if not hundreds of cases that had been decided before they came out with their basically elements-based argument that the board had approved risk, danger, and efficacy of internet dissemination. This is one of those cases. I would disagree with my sister, though, in the statement that he made no mention whatsoever of if the internet should be, a dissemination on the internet should be available to the public. In the addendum at 66, which is the decision of the examiner, he writes just above the order, not only does he find him by clear and convincing evidence to be moderate risk and danger, but that is dangerous to such that a public availability of his personal information is warranted in order that he register as a level 2. And I believe that is the same language that the board has used in the past before 496501. And I think in conjunction with that, the facts of this case showing a moderate risk to reoffense, I would argue that the panel does not have to exercise its discretion and remand this. And to support that also is just the nature and the facts of the case, where he sexually assaulted a child victim over a period of years. As the SJC noted, contact offenders are more dangerous, can have a higher risk than non-contact. This gentleman had multiple contact offenses where he raped the child with force and had rape and abuse against the same child. So I do not agree with my sister that the examiner mentioned nothing about the availability of internet dissemination. He does put that caveat in there, even though obviously he doesn't follow the dictates of the SJC pursuant to 496501. So I would ask that the panel not exercise its discretion and remand it and uphold this level 2. As far as the hearing examiner taking issue with the expert in this case.
Before we get onto that, can you say how this case is different from the case decided last week for 524-553?
Yeah, Your Honor, I read that real quickly, but in preparing for this one, I can't remember the facts of that case. I can't remember what the holding was either. I apologize. Was that what was it, 524?
524-553. It was someone who'd been classified as level 2 by the court after offending against, I believe, his 2 stepdaughters, intrafamilial victims,
right,
either within the home or on the back steps.
Right. Well, when the board updated its regulations and repromulgated its factors back in 2016, they changed the intrafamilial victim definition under factor 7, which is 803 CMR 1.337. Before that, if you had an intrafamilial victim, it would be mitigating, because I guess the theory at the time, or what the research showed the board, was that if you
and now it's just the baseline, and if you
now
go
it's
to
just the baseline, it's for definitional purposes only. It doesn't add,
right,
or it doesn't activate or mitigate.
right.
You do have the same situation here. Factor 7 was not implicated. It was not applied by the hearing examiner because based on that definition, even though it does say you may give it mitigation, he did not in this case. And that was probably because of the nature of the offending, the force, and also the length of time.
Yeah. Well, the relevance in 524, 553 of it being intrafamilial was that the question really set out by the SJC in 496501 is whether, given the particular facts of the offender's prior offenses, internet dissemination is warranted to protect the public. And 524, 553 was remanded for the hearing examiner to consider whether, given that the offenses were intrafamilial and committed in or near the house, whether it was necessary to warn the public via internet. So how is it different from the situation here?
Right. I think the fact that I think the length, I'm not quite sure the length of time of the offending in the 524, 533 case. I think that's very important here. As the child aged in this case and was more able to defend herself or speak out or cry out or seek help, that didn't seem to deter him. I can't remember in the facts if the sexual assaults were anywhere other than in the home. I'd have to review the record. But I think I think it would be incorrect to start looking at intrafamilial victims the way it used to be before the repromulgation of that factor. The board has relied on the research that said, yes, it could be worth mitigation, but at this point now it's not. And I think the fact that the nature, as I keep saying, the nature of the offense, the sexual assaults over a long period of time, a contact offending, a child that can't defend herself, extra vulnerable. I think all of that in total shows that there shouldn't need to be a remand. And adding on to that,
can I ask you, Mr. Doyle, before you leave the subject, Ms. Green says that because it's the same victim in the same home over the time and not offenses against outsiders and not since he's been released from custody, why does he remain a danger to public safety that require internet dissemination?
Well, I think you need to look outside the scope of the of just the hearing process itself. You have a situation where a gentleman, I don't know what his marital status is. I don't know if he's dating anyone, but in the future, if he does have, if he either gets married, has his own children, or marries somebody with children, and those children have someone to come over and play. If the fact that it's an intrafamilial victim isn't as important as it used to be, and you bring other children into the situation, I mean, I know that might be a long shot, or it might be really out there to make that suggestion, but who are we trying to protect here by putting this gentleman on the internet? It's underage female children, as the SJC says, past his prologue, underage children, extra vulnerable children under the age of 8. And that might not just be somebody who, if he either marries into a situation like that or has his own children, it could be anybody that a playmate from school, a playmate from pre-care, somebody just from the neighborhood. And I think that's why internet dissemination.
Are those facts so clear on this record that we can decide it ourselves, or should we leave it up to the hearing examiner on remand to decide it?
Well, I think if plaintiff is going to speculate, well, it's an intrafamilial victim and nobody needs to know outside the family, I think it's just as easily to speculate, as I just said, that if he's in another situation with either his own child, a stepchild that has visitation from other children, the parents of those children or the parents of those schoolmates should know that a level 2 moderate sex offender who has violently sexually assaulted a child is in their midst. I would move on to Dr. Bard if I could. Just obviously under 23656, the hearing examiner must put on the record the reasons for disagreeing with the expert. I try to make this clear in my memorandum. They did use 2 different methodologies. Dr. Bard always uses his adjusted actuarial, and the examiner is bound by the board's factors pursuant to the statute and the regulations itself. there was one or two other situations where they parted ways, and as Justice Meade said, the hearing examiner found repetitive and compulsive behavior because he sexually assaulted over a period of years, had time to reflect and stop his behavior, and he did not. And also, I think there was a disagreement about time and community. The petitioner admits in her brief that he was in the community less than 5 years. I would argue, Your Honors, on this record that his level 2 should be upheld, and I'd ask you to find that.
Okay, thank you. Ready?
We are live and on the record.
Welcome to the Appeals Court. I am Justice Meade. With me this morning are Justice Sullivan and Justice Sachs will be the panel for this case. Each side is permitted 15 minutes. If you run into a technical difficulty, no need to worry. We'll rectify it as soon as possible and get back to where we should be. With that, each side has 15 minutes. You needn't use all of your time. I will call the next case. 2020 P25 Broken Arrow LLC versus Joyce Husband and Another. Mr. Alba.
Yeah, good morning, Your Honors. Thank you very much. It's especially challenging with Zoom. It was a last-minute scramble for me to get onto Zoom in time, but luckily the clerk's office contacted me back right away, which was very appreciative. And so I didn't have as much time to organize as I wanted to because I spent about the last 20 minutes getting my Zoom together, but I'm prepared. And I would like to first, I intend to fully focus on what the court issued by way of instruction on last week on Friday, focusing on General Law 239, Section 7, and the Duros case, because the court asked that we be prepared for that. So I am prepared for that. But I'm just going to give a general overview of the case right now and the basis for our appeal. In this particular action, we have a company that has brought suit personally against my clients, Joyce Husband and her husband. And they were running in a business, thank you, a hair salon on Cape many years ago. And they had a business, EGADS Inc., or coiffeurs. And the landlord, Broken Arrow, in the underlying summary process case, had brought an eviction action specifically against the corporation, not against the husbands individually. In that case, we conducted complete discovery, and a trial was held subsequently, specifically in regards to our discovery, and you have that as part of your record appendix. It shows that Broken Arrow was asked, show us all of your leases that form the foundation of your claim, produce documents of showing those leases. They did produce those documents. They took no steps in the summary process action in the Orleans District Court to implead my clients, to make any suggestion that my clients were in any way liable on the debt or the alleged debt or on the rent. A trial was subsequently held before the Honorable Judge Merrick, and who issued a judgment in favor of the plaintiff, Broken Arrow. Less than a year later, about 11 months later, my client contacts me, Ms. Husbands contacts me, and states that they've been served another complaint from Superior Court in which a new lease apparently has been produced, purporting to show that my clients signed personally to be personally liable on the lease. It's important for the court to note that this was done less than a year after the judgment was issued, a final judgment in the Orleans court. And so we brought a motion to dismiss the case under Rule 12b-6 to the Superior Court judge, claiming a collateral estoppel, and also violation of the discovery rules. We had asked for copies of any and all leases in the underlying summary process case. And we essentially argue, and none had been produced, but now lo and behold, we see here in the Superior Court action, there's this lease that's been produced that we asked for, which we were never given. We had a final judgment. We had attempted to appeal that final judgment in the district court because the amount of alleged rent that had been due and the judgment itself was actually quite substantial. My clients at the time, essentially being indigent as they are today, especially after the COVID situation with a hair salon, were not in any position to pay any type of appeal bond. It's important for the court to note that if they had been named individually, that would have, in the district court action, that would have given very strong incentive to do anything, especially to do anything that they could to try and come up with their appeal bond. The Superior Court judge rejected our arguments for collateral estoppel, judicial estoppel, and allowed the case to proceed. We, in due course, opposed the motion for summary judgment that had been brought by the plaintiff, essentially arguing the exact same grounds that we had argued before, that the case should have been dismissed. The court denied that, and summary judgment was issued, and in due course, we filed our appeal. Now focusing on the court's inquiry in regards to your order from last Monday, in regards to General Law 239, Section 7, and to the Duras case and to its note section. It had the footnote that had a specific citation to what the court's looking for today. So first I'm going to focus on General Law 239, Section 7, because it appears that law summary process is a strange animal insofar as that some claims can survive against the parties in limited circumstances, and that the doctrine of res judicata and collateral estoppel doesn't apply. And specifically, I'm just going to focus on the straightforward wording from the statute, which I think is what the case law shows. And the case law is, in addition to Duras, where it actually deferred on a critical question before us today about the res judicata effect. Duras cited Edwards versus Columbia and also Miller versus Campello, which was cited at note 12 in the case. So first I'm going to take a look at General Law 239, Section 7. The plain wording of the statute does show, and I think that's the direction that the Duras court was leaning in, that the doctrine fully applies here, and that this judgment should not have, essentially the Superior Court should not have acted in the role of an appeals court in overturning or supplementing a final judgment of the district court. And the wording is very clever, is very, very clear. General Law 239, Section 7 covers no bar, quote, in any action thereafter, and it very specific what those actions are. And any action thereafter damages for trespass thereon. It then has, like our Second Amendment to the Constitution of the United States, which causes a lot of confusion about what the intent was. It then has a second section that says that Section 5 of General Law 239 does not, it limits, that it states that the judge, essentially that the judgment that could go forward on any new other type of case is limited by the amount of rent. It mentions the word rent. So in other words, the intent of the statute is that, I'm just going to read it, quote, the amount recovered for rent under Section 5 shall be deducted in any assessment of damages in such subsequent action by the original plaintiff. So in other words, read in harmony, one section after the other, a plaintiff in a summary process action who is successful on obtaining possession may bring another action. There's no bar to any action to recover the land or tenements in question. It's very specific. And an action to recover the land or the tenements. It makes no mention of rent. It then goes on to state, but the amount recovered for rent under Section 5 shall be deducted in any assessment of damages in subsequent action by the original plaintiff, quote unquote. Section 5 of General Law 239 has to do with the appeal bond. And in this, so the original judgment in our situation was against the corporation. There was no judgment as to rent on my clients. My clients were no longer in possession. No, there was never any trespass at law on the tenements. Therefore, the plaintiff in the case could have, if my clients hadn't left, if they were still there, if there was an action for trespass or another to recover possession of the property, there was a possibility then under General Law 239, Section 7, that the plaintiff could have proceeded in this case. But we don't have those facts in this case. My clients had vacated.
I hear what you're saying about 239.7. Your premise for your appeal is that claim preclusion barred Broken Arrow from bringing the Superior Court action.
Yes. And
claim preclusion depends on your clients having been either a party to or in privity with a party to the summary process action, which would be EGADS. So What is your basis for saying that your clients were in privity with EGADS?
Essentially, as was briefed, Your Honor, my clients were the principals of the corporation. So that's the hook that we have there for privity.
So what case says that corporate officers or directors are, for that reason alone, in privity with, or are entitled to the benefit or burden of a prior adjudication involving the corporation?
I'm not prepared with the case, Your Honor, but I would cite that the purpose of the incorporation is, as corporate officers, you know, they are employees of the corporation, they are agents of the corporation, they make the decisions for the corporation, and all of these. So in any type of corporate situation, including even a closely held, if I go work for employer A, I have an employment contract with employer A. That would put me into privity with them. So we have basically the same situation here.
So you say that any contract with a party to a prior adjudication creates privity and entitles the contracting party to the benefit of claim preclusion?
Correct, Your Honor. Just like an authorized agent who's working for a corporation would not be liable for the actions of the corporation as long as they act in the capacity of their agency and not going outside the scope of that. I think that's black letter law, Your Honor. Yes.
Why are they in privity if we assume, for purposes of argument, that the corporate form creates a distinction between the interests of the corporation and the interests of the individual? Because the individual is normally not held liable for the debts of the corporation. Are you saying that the privity arises both from the relationship and the personal guarantee, or just from the relationship?
Well, the personal guarantee, Your Honor, our basic argument is that other lease could have and should have been produced and should essentially never have been considered by the court. So there was no personal guarantee in the release that was produced in response to discovery.
I understand that. I'm just trying to understand your argument, because normally the corporate form is erected as a shield against personal liability, which would seem to argue against privity, not for it. So I'm trying to understand where your argument is coming from. And I should say, I stand ready to read any case law on this that would illuminate it. I'm just posing the question.
Yeah. Again, my response would be basically identical, Your Honor, to my previous answer. And if the court would allow me to have leave to come up with fine cases on that, I think I would be able to do that. But essentially, it comes down to our argument is down to agency. They are fully authorized agents of the corporation. They have what essentially is what I would call a contractual relationship with the corporation, and that would be the shielding that they would have from personal liability in this case. And just as an employee for a company, I'll play the devil's advocate here for a second. But if Amazon rents a big warehouse and they have managers there working there who might be corporate agents of Amazon, and they get evicted for not having paid, would it be proper in that circumstance for the landlord to sue that particular agent for Amazon, even just relying on the fact that they were one, an employee, and two, that they were an authorized corporate agent who may have or may not have signed a lease on behalf of Amazon? I think that's pretty clear that individual wouldn't be liable to have to pay any of the rent that was alleged due or by any previous judgment in those circumstances. In regard, I would like to continue though, just in regards to Duras, where it cites Edwards versus Columbia Amusement Company. In that particular case, Duras did note, because the issue of liability on the lease had been fully and finally resolved by the court. The court in Columbia had made a two-part conclusion that in regards to the effectiveness of the foreclosure, and also in the regards to the effectiveness of the final judgment on the lease. And in Duras, the court did not. They found the issue. This is the quote from the case at 839, citing Edwards. The issue concerning the effectiveness of the lease had indeed been finally and fully resolved. that would have been on the summary process eviction case. So I think that that is essentially what we are arguing here as well, that the effectiveness of the lease had been fully and finally resolved in the district court case. So I do believe that the court in Campello as well really did resolve the situation, and essentially supports my argument that that the general law 239 section 7 only covers actions for damages to trespass thereon, as far as allowing the open door to be open for further claims in those situations. I think that you have it there, Your Honors.
Okay.
Those are
Thank you very much.
the gravamen of my arguments.
Thank you. Mr. Kelly.
Yes, good morning, Your Honors. Your Honors, first of all, I'm hearing for the first time about a letter from the court on Monday about chapter 239 in a particular case. I'm not prepared to address it because I never received the letter. But be that as it may, I can address, first of all, the status of the husbands. If the court were to examine the lease, which is in the appendix several times, the lease is both husbands are parties to the lease. The discussion thus far has been, well, does an officer of a corporation have a responsibility just because they're an officer of the corporation? That's not what position we've ever taken. Our position is that they're parties to the lease, they're co-obligors, and we address that in our brief. Having said that, Your Honor, first of all, the postural situation that this comes to the court is that a claim that the motion to dismiss should have been allowed. And our first argument is that the law that Mr. Alva cites is the correct law, but its application is wrong. He asked the trial court to make an assessment and on documents that were outside the complaint. For instance, he answers to interrogatories, requests for production of documents, notices to quit, checks, letters, and invoices. He added those as part of the motion to dismiss, and they're outside the record. For that reason alone, the trial judge should have denied the motion. So, Your Honor, having said that, go on to the next two issues, which I think are important in resolving this case. And I think the issue becomes whether, first of all, that the husbands were a necessary party or an indispensable party under Rule 19 in the summary process action. And my position is that they were not.
If we could stop for a moment, it appears that we have lost Justice Meade.
Your Honor.
Just a second.
We are live and on the record.
Go ahead, Mr. Kelly.
Yes, Your Honor. Your Honor, I just want to make sure that the court understands. I don't know how much you heard, but one point I think is crucial to resolving this is that the Broken Arrow is not proceeding on the theory that of, in effect, piercing a corporate veil and trying to impose liability on corporate officers. Rather, we look to the language of the lease, which talks about both Mr. and Mrs. Husband as co-tenants with the corporation. So I think that is a significant difference in when the court evaluates the arguments and the documents before it. Having said that, I want to proceed to the concept, three concepts dealing with whether or not the husbands were necessary parties. The first point I would make is that restatement of judgment allows a joint or joint and several liability type of situation to be taken advantage of by a creditor. So as I understand restatement judgment 1105, the court would say that an absent joint tenant was not was still bound by the judgment of the first court. Secondly, the rules of summary process.
Sorry, Mr. Kelly, you
Yes,
said
sir.
statement section 1105.
Yes, Your Honor.
I don't think it goes up that high. Is there maybe another section that you are referring to?
I'm reading from my notes. I know I make reference to it in my brief, Your Honor.
Okay.
While we're paused, the threshold issue which has been raised is whether or not you're permitted to assert the lease now that has their signatures, because it wasn't produced in discovery in the prior action. What do you say to that?
Well, it wasn't produced, Your Honor, because we didn't know where it was. Again, in my supplementary affidavit, my supplementary appendix, I have the affidavit of Mr. Etchcorn, who is the principal of the plaintiff LLC, and in it he said that they searched for it and couldn't find it.
I understand that, but does that matter? If you've had a prior litigation and failed to produce it for whatever reason, and let's take the representation that they couldn't find it, does that matter?
To be honest with you, from my readings of the cases, Your Honor, I don't think that it does. For instance, say if the situation were a little bit different and you couldn't, and it's sort of addressed in Rule 19, that if you couldn't find a defendant to serve them, say a joint defendant, you could still proceed against the other defendants, and you could apply, and as the way I understand Rule 19, you could apply that judgment against the absent joint tenant. So I don't think it matters that, I would suppose that the court would be a little bit concerned if it was some sort of skullduggery or fraud, that you just hit it so you could come back later. That's one of the reasons why I advanced it in going into the Superior Court judge, is to show that it was in effect excusable neglect.
Did the husbands ever ask as a discovery sanction in this action or the other? Well, it would have to be in this action, that the new lease be stricken?
No, Your Honor.
Okay.
If I could proceed, the rules of, Your Honor?
Yes.
Yes.
Okay. Okay, the next area I turn to is Rule 19. I'd say that it applies in this case because the rules of summary judgment does not address the issue of joinder. So, but it does say that if plausible, that you should look to the rules of civil procedures. So that's what I've done in this in my brief, is talked about Rule 19, dealing with what is a necessary party and an indispensable party. My position would be, based on the restatement and based on the lease, that the tenants are not, the husbands are not necessary parties to the summary process action. The first part of the rule talks about complete relief to be given, and complete relief could be given. They had the ability to represent their own interests. In this particular case, the husbands were there. Mr. Husband was served as an officer of the corporation. I don't think there's any dispute that Mrs. Husband was present at the trial. And finally, it would be a necessary party if that party would be subjected to multiple liability. In this case, the liability is joint and several on them because each of them are a joint tenant with each other. And in the way I envision it, if one party paid $20,000 towards the judgment, and it would be open to the judgment holder to be able to collect the balance against the other two parties. So I would say that the husbands are not necessary parties. Finally, Your Honors, on this particular issue, I cite a case, Janie Montgomery Scott Inc. versus Shepard Niles. It's a 11 Fed 3rd, 399 Third Circuit case, which talks about Rule 19. And at page 410, it says the case law and commentary that supports the proposition that one co-obligor may be sued without joinder of its co-obligors implicitly supports the proposition that issue preclusion for or against an absent co-obligor is not a consequence of any final decision for or against an obligor who is present as a party in a contract action. That case sort of hits on what we're talking about here, and although it's not the law in Massachusetts, it is a federal case in one of the circuits and has some sort of persuasive value. And I'd ask the court to examine that and apply that to these facts. Finally, Your Honor, Massachusetts represents affirmative collateral estoppel, and I think that the case for that proposition is Pierce versus Morrison, Mahoney, and Miller. And also of some import, I think, is a Supreme Court case, which I also cite, Taylor versus Sturgis. And in that case, what happened, one party filed I believe, Freedom of Information case in federal court. They then, they lost it there, and then a friend filed relatively the same thing. And the issue was whether or not the friend who filed the subsequent complaint was bound. And Justice Ginsburg, in her opinion, talks about 6 circumstances. In this case, the 2 of them applied. One is permitting legal, dealing with prior legal relationships. And in this case, the prior legal relationship among the defendant is that they were all joint tenants under the lease. Secondly, adequately represented.
So
yes, Your Honor.
That's the Taylor case was talking about circumstances in which issue or claim preclusion could apply, and they're saying that one of those is where there's a prior existing relationship. So assuming that co-tenancy is one of those prior relationships, then why doesn't that favor the husband's position in this litigation, that the prior judgment bound not only the corporation, but also them personally as co-tenants?
That's what I was saying in the Superior Court, because of all these factors, that the husbands were bound by it, by the judgment as well, because they were co-tenants.
But where they weren't, why can why isn't the claim precluded because it could have been asserted against them in the first action?
Well, I respectfully disagree with your premise, Your Honor. It couldn't have been asserted in the first action because we didn't have the lease, and secondly, the assumption, and my client, I think, averts to it in his affidavit. The assumption is that they were guarantors, and of course, you couldn't proceed on a guarantee claim without a writing. And we didn't have a writing to impose liability. When we found the lease, we determined that they were joint tenants, and felt that they had joint and several liability because of the joint tenancy under the lease.
So you're saying that the fact that your client wasn't a good record keeper, in essence, should be held against the husbands as the defendants, because your client couldn't come up with the lease in the first action. He's free once he finds it to bring a separate action.
That would be my position, Your Honor. And also, it's not as unfair as you make it sound, because it seems to me that the husbands had the benefit of the use of the premises for all these years without paying for it. So it's not like they're totally innocent parties. I mean, I don't know what equitable considerations would be involved, but I don't think they'd be entitled to any of them under the circumstances.
I'm curious, did Did Broken Arrow do any discovery in the summary process action to see what copies of the lease the husbands might have?
No, Your Honor. May I proceed?
You have 25 seconds.
Okay, I just say that they were adequately represented in the sense that the husbands were there at the trial. And I thank you for your time, Your Honors.
Thank you. Thank you. Thank you both. We'll take this under advisement.
We are live and on the record.
Welcome to the appeals court. My name is Justice Meade. With me today are Justices Sullivan and Sachs, who will be your panel for this case. Each side gets a total of 15 minutes. You needn't use all of your time. If we have any technical problems, we'll pause and reestablish a connection. With that, we'll call the next case 2019 P 1769, George PISARCZYK versus Ben Lynch and others. Did I say your name right, Mr. PISARCZYK?
PISARCZYK.
Okay, go right ahead.
Okay, now, so I start the oral argument.
Yes.
Okay. Okay. I made a request to Mass DEP to designate Lake Lashaway a Great Pond as an applicant in accordance with 902 definitions Great Pond by providing topographic, historic, and other information, including analysis demonstrating that the original size of the pond was more than 10 acres. My details of this request are provided in, and I'll give some references. A brief for plaintiff, paragraph 3, plaintiff statement at 9, and appendix volume 3, record appendix 3, exhibit 3-2 at 50. And I'll continue.
Mr. PISARCZYK, you can count on the fact that we've read your brief very carefully and we have your references. So you can just tell us what you want to tell us. I should say that the way the case has come to us is that the merits have never been reached. This is only before us on the statute of limitations and the legislative immunity of certain officials. Now you can tell us anything you want, but those are the two issues that we have in front of us.
Okay, I'm not sure I understand your issues, but let me see if I can, if you read the brief and everything, basically what I want to say is that when I made a request to Mass DEP, they responded with a letter, and it was a March 28, 2016 letter. And the reference to that letter is appendix volume 3, record appendix 3, exhibit 2 at 9. That is that's the letter I'm referring to. Well, Mass DEP constructed that letter as if I was an applicant submitting an application for a license or permit for a project, which I wasn't doing, and that puts me in a different situation as far as what my responsibilities are. And I guess the other thing I want to say is in this letter, in this letter that I'm referring to, the WRP said this. They said the WRP reviewed your information submitted as a part of the request and determined that there is sufficient evidence to consider designating Lake Lashaway a Great Pond and adding it to the Great Pond inventory list. My position is that is a statement, basically a determination statement, which means that Mass DEP should have pursued the public hearing in accordance with 910 3B. And they didn't do that. And what they did is the public hearing that they came up with is what I feel it's not accordance to 310 CMR 9. First of all, they don't have jurisdiction unless they have a public hearing that is according to 910 3B. And that public hearing occurs only if they made the decision that they made a decision that the Lake Lashaway Way is designated as a Great Pond. Now, if they didn't do that, they shouldn't have had a public hearing at all. And the public hearing they had, they didn't have jurisdiction. They didn't have geographical jurisdiction. And further, let me say, I'll look at the notice. The notice that was part of the March 28, 2016 letter says, public notice is hereby given of a request received by the Department of Environmental Protection Waterways Regulation Program to designate Lake Lashaway, North Brooklyn, and East Brooklyn as a Great Pond pursuant to 310 CMR 910 3B. But that notice is not pursuant to 910 3B. That's a notice of a request that I made, and basically it appears to me that is a meeting without purpose. And it appears to me it shouldn't be a meeting, any public hearing based upon a request that I made, only on a request that I made, a request to designate Lake Lashaway a Great Pond.
So, Mr. PISARCZYK, may I ask you a question?
Yes.
Let's assume you're right, that DEP didn't follow the proper procedures in ultimately rejecting your request to designate Lake Lashaway as a Great Pond. What I hear DEP arguing, and the other defendants, is that you didn't bring this lawsuit within the time required to challenge DEP's decision. So they may have been right, they may have been wrong, but either way, if you wanted to challenge it, you needed to bring it within 60 days at the most.
Well, you know, I'm challenging it on the basis of fraudulent activity. And I have, when I do that, I have 3 years. And that's on the basis of that I'm promoting this this case. And
You're talking about the statute of limitations for bringing a damages claim against someone for
against the Commonwealth.
All right. Well, in the Commonwealth, when you want to bring a lawsuit for negligence, you need to let the Commonwealth or a city or town, for that matter, know that by presenting the claim to them in a letter within 2 years of it happening. And then if they don't resolve the case or settle it somehow, then you can sue within 3 years. But that wasn't done here, was it?
No, because the material I read says I had 3 years. It says within 3 years. It didn't say I had to contact anybody. And I actually, I should have a reference. In fact, I will look. What I'm doing is I'm looking at the brief supplement for the plaintiff. And let's see if I can find. So I was referring to Massachusetts General Law, Part 3, Courts, Judicial Officers, and Proceedings in Civil Cases. And and what it says is the court shall have exclusive original jurisdiction of civil actions for and of claims against the Commonwealth. Then I have General Law, Part 3, again, courts, judicial officers, and proceedings in civil cases, statutes of frauds and limitations. And it says, Section 3, petitions founded upon claims against the Commonwealth prosecuted under Chapter 258 shall be brought only within 3 years after the cause of the action accrues. So those are the things that, and I said further, the plaintiff did not seek an order that DEP designate Lake Lashway a Great Pond in the complaint. In other words, I wasn't requesting any judicial review.
You're not requesting judicial review?
I'm not, no, it's my position that the public hearing that was conducted by DEP prevented any person from appealing or providing a notice of a judiciary hearing, and nobody did. Nobody did, nor did DEP accept such an adjudicatory hearing.
So are you saying that you're bringing a fraud claim for damages against these defendants and not an action for judicial review of DEP's decision?
Yeah, that's what I'm saying. I'm saying that the DEP public meeting did not comply with the 3 CMR 9 regulations, and also they did not have jurisdiction. So Chapter 91, Section 35 also did not apply to any activity that they did. So everything they did was not under Chapter 91.
You have 3 minutes left. Is there anything else you'd like to tell us, Mr. Parzyk?
Yeah, what I would like to say is that the DEP in the March 28, 2016 letter, they imposed requirements on me that were not legal, and they misrepresented my responsibilities when I made the request for Lake Lashway to be a great pond, in that I have absolutely no responsibility. Once I make the request, WRP has the only person that should be responding. They should be responding to my request. I have no further responsibility, but in that March 28, 2016 letter, they made me advertise that public hearing, which I consider a illegal public hearing, and I had to advertise it, and I spent over $100 advertising that public hearing. But that was not a public hearing that gave notice to a meeting in accordance with 910(3)B. So they had a notice that was not accordance to 310(9), and they did not conduct the notice that they said they should. And I'll quote. And what I'm going to do is I'm going to quote their, if I can. Okay, what they said is, and I'm going to quote exactly what they said: pursuant to 910(3)B, the WRP must hold an advertised public hearing in the vicinity of the designated Great Pond to formally notify residents of its intent to consider adding the Lake Lashaway to its Great Pond inventory list. And they never gave that notice, and their notice was completely, I consider, bogus.
Okay, we understand, Mr. Presiding. Your time has expired, so we thank you for your argument. Now we're going to hear from Mr. Hale first, I believe.
Good afternoon. May it please the court. Andrew Hale on behalf of the Department of Environmental Protection and the state elected officials who are Senator Goby and Representative Berthume. I want to begin by just acknowledging just the extraordinary amount of time and effort and passion that Mr. Pisarczyk has brought to this issue and to his desire to have the Lake Lashaway as designated as a great pond. The basic dispositive question for the court, however, is that Mr. Pisarczyk filed his complaint over 2 years late. So DEP in March of 2016 initiated a public process to determine whether to designate Lake Lashaway as a great pond, which, as you know, is a designation reserved for bodies of water who, in their natural states, defined as the 1640s, as they were in the 1640s, is for bodies of water 10 acres or more. Does not apply to man-made bodies of water or bodies of water that were dammed. In April 2016, DEP had a public hearing in the vicinity of the pond, and there was a number of folks that came out who spoke in opposition to the designation of Lake Lashaway as a great pond. In September of 2016, DEP issued its final decision in this case, which determined that Lake Lashaway was not a great pond and therefore would not be designated as such. Mr. Pisarczyk waited until February of 2019 to file his complaint. And even though he doesn't agree with the idea that this is an administrative agency appeal, there is no other conceivable cause of action except for the certiorari statute, chapter 249, section 4, which requires that complaints under that section be brought within 60 days. Again, Mr. Pisarczyk brought his complaint over 2 years later, and that deadline is jurisdictional, as the court is aware. And so
he seems to be saying that this is not an action for review of an agency decision, but an action under the Tort Claims Act for fraud.
Your Honor, that I heard that. That is the first time that I have heard that particular argument from Mr. Pisarczyk. I don't read his complaint as saying that. And I think just looking at the complaint, the causes of action, they all discuss sort of DEP's failure to comply, alleged failure to comply with their own regulations. They should have used 9.17 instead of 9.10 and so forth. And so to the extent that he's arguing that, his complaint does not bear that out, nor has that really been argued at any point during these proceedings until now. As I understand it, the regulations do not specifically prescribe an appeals process for a request to designate a body of water as a great pond. They do in section 9.17 discuss an appeals process for individual applicants for example, a license or permit. So if somebody has a dock, for example, that's on a great pond, they might need to go through a licensing procedure for that. And there is a right of appeal from that. I don't read the regulations as having an explicit right to appeal from a designation of a great pond. And so arguably, I think Mr. PISARCZYK's only cause of action would be the certiorari statute. But again, there's a 60-day deadline to bring those cases, and he failed to meet that here.
So in your view, it's unclear whether this is a 30A or a certiorari?
Your Honor, I think it would properly be brought under the certiorari statute, just because 30As is reserved for final agency decisions following an adjudicatory proceeding, and I don't think this particular public hearing process would have qualified as an adjudicatory proceeding. I would respectfully say the question is sort of academic at this point, because even if it were brought under 30A has a 30-day deadline, certiorari has a 60-day deadline. Again, we're talking about 2 years later. So happy to go ahead, Justice Sachs, if you had a further question there. Oh.
Yeah, unmute your mic, Peter.
You're muted, Justice.
The 30 or 60-day deadline may take care of the action against DEP, but what about the actions against the state legislators? Which
certainly, Your Honor. So 2 points with respect to that. First, there's an issue of absolute immunity for legislators taking actions within the purview of their offices. So this immunity stems from Article 21 of the Massachusetts Declaration of Rights, which is known as the Speech and Debate Clause. And that provision protects legislators, ostensibly engaging in speech and debate on the floor of the House or Senate. The SJC has considered that provision and said it must be liberally construed to cover not just literal speech and debate, but also any legislative act that's taken arising from the function of a legislator's office. And so in this case, Senator Goby and Representative Berthume wrote letters to DEP during the public hearing process, and those letters expressed the opposition of their constituents to the designation of Lake Lashway as a great pond. That is an act arising from the function of their office as elected officials representing these communities, and so it would therefore fall under the absolute immunity.
It's a constituent service. It's a constituent, it's a nod to the constituent, but is it part of the legislative duties and process of a legislator to express an opinion to an executive department agency? And if so, what case says so?
Your Honor, I would direct, the answer is yes. I would direct you to the Coffin versus Coffin case. That's for Massachusetts 1. It's a very old case from the 1800s, but that's the case that says, look, courts must construe this liberally. It's not just literal speech and debate. It's any act arising from the, quote, function of their office. And so in this case, you have elected officials who represent a particular community. The community is calling them and saying, we don't want this thing, we want this lake to be designated a great pond. All of a sudden, all the residents with properties along there may have to deal with licensing and permitting, and we oppose this. Please let the state agency know. That is an act arising from their office.
So you're saying that constituent service in this instance is part of the function of the office, but we are both looking to Coffin versus Coffin for that. You would be looking to Coffin versus Coffin for that proposition. We haven't had anything since then.
That's correct, Your Honor. The lower court did also cite a U.S. Supreme Court precedent, the Bogan-Harris case, which I think is speaking more broadly to absolute immunity that's enjoyed by legislators. And it does say state, local, and national legislators. It's kind of, the basic doctrine, though, this is the sort of thing you have a state representative, a state senator who's known within the community. You're going to run into this person in the grocery store. This is the kind of thing that this absolute immunity is supposed to protect. It's legislators who are saying, we're here advocating on behalf of our constituents. Just because we're not debating on the House floor, we're casting a vote, we're still acting in our function as legislators, and therefore we shouldn't be sued for that activity. Justice Saxon.
Weren't the facts in Coffin that a claim was allowed to proceed based on something that one legislator had said to another in the cloakroom off of the, I think the House of Representatives floor?
I think that's right, Your Honor.
So it's broad, legislative immunity is broad as far as it goes.
It certainly is, Your Honor. I mean, I think, as we all know, that the idea, the function of legislators in today's world versus 1808 probably looks a little bit different. But again, it's the same principle that applies, which is if you're taking an act that is sort of generally related to your function as your office as a legislator, you should be protected from that, from civil suit based on that. I would also. Oh, go ahead, Your Honor.
If we were to disagree with you about Article 21 being applicable here, what do you have any other arguments as to why this shouldn't go back, at least as to the state officials?
Yes, Your Honor. And that leads me to my final point, which is that the complaint, just on its face, fails to state a plausible claim for relief. So just briefly, Mr. PISARCZYK alleges against the state elected officials that they conspired to submit false and misleading information to DEP when they engaged in the process of writing a letter to DEP on behalf of their constituents, and that this was a sort of improperly influencing the process. He does not. I just heard just now that apparently this might be brought under a sort of negligence theory or a tort claims theory, but he doesn't say that in his complaint. And in any event, that all that the legislators did was write a letter to DEP saying my constituents oppose this. There's nothing within that fact pattern which would rise to a plausible claim for relief, and the complaint can be dismissed also on that basis. Thank you very much, Your Honor. I would just ask that you would affirm the dismissal of the lower court.
Thank you. Ms. Quisel.
Thank you. If it may please the court. Amy Questel, KP Law. I represent both the town of East Brookfield and the town of North Brookfield. The towns in this situation are in a little bit different position because they made no decision. Under Chapter 91, they have no duty owed to the plaintiff. The Chapter 91 regulations require that when there is a hearing that notice goes out, there's a public hearing, notice was sent out inviting comments, and both towns provided comments with specifically with historic data and historic information. That historic information led to the fact that this was the 5 Mile River, which was dammed back in approximately the early 1800s. So therefore, in its natural state, it was never 10 acres. And essentially, that's it. Those were the comments by the town. I would say that again. I would. I'm not going to. I won't repeat what the Commonwealth has already argued. I would just say that there is failure to state a claim. There's also, again, the timing issue. The MTCA just came up. I would agree that that just came up this morning. However, there's been no letter of presentment to either town. And further, the town also somewhat enjoys immunity based on its so-called legislative acts, which these letters were signed by both boards of selectmen in their entirety. And again, there's really no dispute as to the letters were not necessarily opinion letters. The letters basically just said, here's the history that we have, and this is why we don't think this should be classified as a great pond. I have nothing further unless you have any questions for me.
Seeing none, thank you. Thank you all.
Thank you.
We'll take this under advisement.